Star wins, but by how much? Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. The Supreme Court does seem to be stretching out the drama, the high drama of their big opinions. And you'd think it would be a total anticlimax by now, but rest assured, it isn't. Today, the court decided 6-3 that a football coach who had lost his job for midfield prayer after games should get his job back. The school district, in fear of breaking the Establishment Clause, broke the free exercise and free speech clauses instead. Neil Gorsuch said outright that no government entity has any duty to suppress religious observances, close quote. We're going to talk about that case. And that includes many things that might surprise some of you. If you don't live in the Seattle television market where much of the drama played out, or maybe if you don't remember it, after all, it happened about 7 years ago, then this will come as a surprise. And stick with me to the end, because I'm going to show you that Coach Kennedy conceded too much at the outset, and this victory might not be as far-reaching as the screeching banshees in the mainstream media are going to make out. Before I begin, I do want to shout out to the sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, including this t-shirt I'm wearing, Rhino Hunting. All right, ladies and gentlemen. Now, once again, we're going to talk about what Coach Kennedy won and what he might have thrown away before he began and maybe shouldn't have. Before I begin, I need to give you another Supreme Court update because the court is not finished handing out opinions for this term. The case of Kennedy versus Bremerton School District is one of 3 opinions the court released today. The other 2 cases involved sentencing for distribution of crack cocaine and the extent of authorization to doctors to prescribe a controlled substance in some cases. In addition, the court released a slew of orders containing the usual denials of certiorari, but many of these orders were summary judgments in cases involving attempted interstate robbery, apparently violating the Hobbs Act. The court had earlier decided another such case, U.S. versus Taylor, in favor of the defendant. Today, it remanded a large number of similar cases, saying in effect, see what we wrote about James Taylor. Now, all this leaves 4 cases remaining to decide. Kennedy was what I call a Rolling Stone case, one of several the outlet mentioned as likely to further the Republican line. The other 2 are Biden versus Texas, concerning whether President Biden had the authority to rescind President Trump's Remain in Mexico policy, and West Virginia versus Environmental Protection Agency, on whether or not the EPA may regulate carbon dioxide as a pollutant. Now, how the court could decide either case is anyone's guess, especially in light of the other 2 cases decided today. The court has designated June 29th, the last Wednesday of the month, to issue more opinions. Now, is prayer in school ever acceptable? That was the central issue with Coach Joseph Kennedy. I've left a link in the description to the opinions so that you can read it for yourselves. Coach Kennedy did at first pray alone. He prayed with players only after they asked to join him. These sessions grew to include most of the team. In fact, the team, by tradition that began before Coach Kennedy came, had a habit of group prayer in the locker room, before and after games, but never once did Coach Kennedy insist that any player take part in the prayers with or without him. And for more than 7 years, no one complained. And then in September of 2015, an employee from a school other than where Kennedy coached said some good things about these practices to the superintendent of schools. Immediately on September 17th, the district sent Coach Kennedy a letter. The essence of it was, stop all prayer activities. Stop your motivational speeches that include prayer or other religious expression, and avoid saying anything about prayer to players for or against. The district also ordered Coach Kennedy to avoid even the appearance of endorsing prayer or other religious concepts or activities. In fact, the district wrote Coach Kennedy of a direct tension between the Establishment Clause and his freedom to speak and exercise his religion. Now, Coach Kennedy at first tried to comply. And as I'll say at the end, I don't think he should have done this. He stopped all his activities with players, though again, some of these were traditional even before he started coaching there. But when it came to stopping his own personal midfield prayers, he balked. Or maybe, just maybe, the Lord spoke. Not even to offer his own prayer would break his commitment to God. So one fine day he drove back to the school, walked out onto the field, and prayed. Everyone else had already left the field. Then he lawyered up. Through his lawyer, he wrote the district describing his attempt to comply with everything except refraining from personal prayer. He politely asked the district to let him pray on his own. The district, writing back, said no. He must never do anything openly that could suggest to anyone that he was endorsing prayer while on duty. Otherwise, the district could have an Establishment Clause lawsuit on its hands. In point of fact, no record exists of an Establishment Clause complaint against the school or the district. Coach Kennedy would then take to praying privately, but inevitably adults and or players, not from the school's team, would join him. The event got local media attention, and that seems to have infuriated the superintendent even more. Again, absent any complaint from any atheist, secular humanist, or freethinker, the district finally, after 3 games, put the coach on paid administrative leave. They then closed the field to the public and even had the Bremerton police guard the field. 2015 would be Coach Kennedy's last coaching season. That's when Coach Kennedy sued the district in the District Court for the Western District of Washington State. He sued on free exercise and free speech grounds. Then he asked for a temporary restraining order to get his old job back. The district court literally said, and I quote, that a reasonable observer would have seen him as leading an orchestrated session of faith, unquote. So, no TRO. In fact, the court said the district was correct in fear Establishment Clause liability. The Ninth Circuit agreed with that. Coach Kennedy tried to get certiorari then, but the Supreme Court denied it. Now, that could be because this was the court of Anthony Kennedy, no relation, and Ruth Bader Ginsburg. Or maybe it was just that the Supreme Court does not usually take interlocutory appeals. Oh boy, I heard that. Interlocal what? Okay, an interlocutory appeal is an appeal of some ruling on a case before you have a verdict in that case. But that wasn't all that came out of the Supreme Court then. Justice Sam Alito said that denying certiorari at that time didn't mean the court agreed with the lower court's actions. Perhaps it meant only that the case was not right and wouldn't be right until it had reached a verdict. Nevertheless, Justice Alito expressed concern that the lower courts seemed to be saying a teacher couldn't say grace before lunch. Well, maybe Justice Alito and his friends were trying to tell the lower courts, please don't make us come over there. You probably wouldn't like the result if you do. But if so, things didn't work out as Alito hoped. The case went back to the district court. Both sides did pre-trial discovery. and filed cross motions for summary judgment. The district court found for the school district. In so finding, the court held that the sole reason for the district firing Coach Kennedy was to avoid Establishment Clause liability. Moreover, the court held, again, that the district was correct in thinking that. Again, the Ninth Circuit affirmed the district court. So then Coach Kennedy petitioned for an en banc hearing before all the justices of the Ninth Circuit. Yes, I heard that again. And what? Well, en banc, or en banc, is French for on the bench. Whenever a court with more than one judge or justice has all its members sitting to hear one case, we say that such a court sits en banc. The Supreme Court always sits en banc. The results of that petition strike me as very instructive. President Donald J. Trump has succeeded in appointing enough of the court's present members, that is the Ninth Circuit's present members, that almost half of them are now Republican appointees. This has made the usual 3-judge hearings go 50-50, conservative or liberal. Well, the full Court of Appeals denied the en banc petition, but no fewer than 11 judges dissented from that decision. Several dissenters wrote that the majority based its rejection on the Lemon test. That's from Lemon versus Kurtzman, 1971. That test requires looking at whether or not a hypothetical observer could conclude that a government agency or employee was endorsing religion on the government's behalf. The dissenters must have electrified the judiciary by what they said next, namely that the Lemon test is obsolete. The Supreme Court abandoned the Lemon test long before this case, and most courts of appeals have done the same. But evidently the die-hard bare majority on the Ninth Circuit insists on keeping the Lemon test alive. And with that decision, Coach Kennedy again asked for certiorari. This time, he got it. Now, maybe he got it because now we have the court of Brett Kavanaugh and Amy Coney Barrett. In any case, Justice Neil Gorsuch wrote the court's opinion. First, says Gorsuch, Coach Kennedy showed clearly that the school district burdened his own sincere religious observance. Here's the key. The school district never disputed that his prayer custom is a sincere expression of faith. And because the district disciplined him specifically for his religious activity, that in itself made their policy non-neutral. The district also made the mistake of accusing him of failure to supervise his players adequately post-game, but it does not discipline other coaches who leave their players unsupervised to take personal telephone calls and such. Therefore, their policy was not generally applicable. Justice Gorsuch went on to say, and I quote, that neither teachers nor students shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, unquote, Justice Gorsuch. Now, obviously, this did not mean that Coach Kennedy could say anything anytime, but his prayer activities were private matters and never official school or other government policy. So what other argument did the Ninth Circuit have? That Coach Kennedy, as a role model, couldn't help but endorse prayer. Justice Gorsuch rejected out of hand this excessively broad job description. In fact, he echoed Alito's earlier concern about a policy that could forbid a teacher to say grace before lunch. These showings put the burden on the school district to show that firing Coach Kennedy was part of a policy serving a compelling interest and narrowly tailored to serve that interest. And does their policy meet those tests? No. Again, the school district and the lower courts relied on the Lemon test. So even though the school district never endorsed Coach Kennedy's prayer activities, they felt even allowing them would fail the Lemon test. Justice Gorsuch thumped the lower courts for forgetting that the Supreme Court does not regard the Levin test as settled law anymore. And then he said this, and again, I quote, "This court has since made plain, too, that the Establishment Clause does not include anything like a modified heckler's veto in which religious activity can be proscribed based on perceptions or discomfort." Therein lies the problem. The Bremerton School District was applying a modified heckler's veto, and because no one else had ever complained, that made the superintendent himself the heckler interposing a veto. Now, according to Gorsuch, the school district must have known that its Levin test argument would fail. So, they introduced another argument in their brief. According to it, to let Coach Kennedy pray would be to coerce players to pray. Lay aside whether petitioners for certiorari may introduce new arguments they never advanced earlier in the case. In fact, the district never adduced one scintilla of evidence that Coach Kennedy was coercing anyone to do anything, with one possible exception, and I'll get to that. To that, Judge Gorsuch offers a smackdown for the entire woke crowd. Quote, "Learning how to tolerate speech or prayer of all kinds is part of learning how to live in a pluralistic society, a trait of character essential to a tolerant citizenry." Shazam! The woke crowd lives by a maxim that they never tolerate prayer or any other speech with which they disagree. Justice Gorsuch just proved what lay at the heart of the district's attitude, namely that the superintendent is a woke crowd denizen applying typical woke values. This should surprise no one, because Bremerton is a suburb of Seattle. You remember the Capitol Hill Autonomous Zone, don't you? The wackiest nuts you've ever seen are in Seattle. Hey, you asked for it, but I digress. Gorsuch went on to say that high school students, while not adults, are still mature enough to understand that permission does not equate to endorsement. Did Coach Kennedy coerce prayer by command, implication, or example? Allegedly, some parents said so after Coach Kennedy lost his job. The school district says some parents told its staff that their sons had, and I quote, participated in the team prayers only because they did not wish to separate themselves from the team. Funny, says Gorsuch, those team prayers were part of the locker room tradition that Coach Kennedy, at the demand of the superintendent, ended. No player on his team joined him in the midfield prayers at issue. Tellingly, opposing team players did. Now, what authority did Coach Kennedy have over them? None. Finally, the school district seems to say that any religious activity by a teacher where students can see it is ipso facto coercive, which means, and again I quote, that the only acceptable government role models for students are those who eschew any visible religious expression. Now, to eschew means to avoid. That, in turn, means that the government must promote atheism. Chief Justice Roberts and Justices Alito, Barrett, and Thomas all join in this opinion. So did Justice Kavanaugh in all but the free speech burden part. Note, not that it mattered, because the free exercise burdens was enough to shift the burden onto the school district. Justice Sotomayor, no surprise, wrote the dissent in which Justices Breyer and Kagan joined. But before I get into it, I want to shout out to another sponsor, BitNext. This is your replacement for Zoom, Slack, the Google G Suite, Microsoft Office 365, Dropbox, WeTransfer, and Chili Piper, among others. Unlike any of them, BitNext protects your content and conversations so well even the administrators can't see it. So this is your channel for secure comms, conferencing, cloud storage, and file sharing. Best of all, Everything is back-end, so you don't even need client software. If you have a browser, you can use BitNext. Follow the links and give them a try. 28 days free of charge. You can't beat that with a stick. Okay, so let's get to Justice Sotomayor's dissent. Now, she alleges incorrectly that this case is about Coach Kennedy's activities before the games in question. Hey, do you know what she just did? She tried to make this ex post facto. The Constitution forbids that. Or did she forget that? But she also observed something that the majority probably would not dispute. She accuses the court of overruling Lemon versus Kurtzman. Now, the only dispute here is whether the court had overruled Lemon long before this. What one cannot dispute is that if Lemon were not a dead letter before this case, it is now. Sotomayor clearly laments that. In fact, Sotomayor continues her advocacy for strict separation of faith and state, which she mislabels as separation of church and state, that she held forth in her dissent in another case from this term, Carson versus Macon. Indeed, every word of her dissent, beyond misrepresenting the case record, reeks of contempt for the Christian faith. Recall how her dissent in Carson versus Macon began. This court continues to dismantle the wall of separation between church and state that the framers fought to build. That statement, of course, is utterly without foundation, as John Adams could have told her. Now, there were two concurrences to this, and they were very short. Justice Clarence Thomas voted to uphold the judgment of the court, but in his two-page concurrence, he says the opinion does not go far enough. It does not address fully, in his view, what rights a public employee has under the Free Exercise Clause, nor does it address exactly what burden the employer has when seeking to justify disciplinary action that touches an employee's free exercise of religion. The court addressed Coach Kennedy's free speech rights, but not necessarily his free exercise rights. Justice Sam Alito's concurrence runs to one paragraph of 108 words. He has only one quarrel. This case does not lay out exactly how to evaluate the private acts of an employee during a brief lull in his duties. And so I come back to my first question. Prayer wins, but how much? At best, prayer wins a partial victory in this case, like the Allies taking a toehold on the Normandy beaches after D-Day. This is not the capture of Monte la Difensa, as in the Dobbs case. It is not even the holding of the Allied line in the Battle of the Bulge. In fact, one could almost argue that this victory is like that in the Battle of Britain. Coach Kennedy gets his job back, but look at what he had to give up. He should have taken the district at court with its very first letter of September 17. How dare the district order Coach Kennedy to end a locker room prayer tradition that existed before he arrived? And how dare they apply the modified heckler's veto when no heckler had ever come forward? Let's remember how soon Coach Kennedy did file this legal action. Immediately after the district suspended him. Lay aside Sotomayor's ridiculous attempt to make ex post facto law. He tried it the district's way and lost anyway. You cannot be woke enough for a member of the woke crowd. That first letter Coach Kennedy got was patronizing, insulting, and inexcusable. He should have taken them to court right then, instead of conceding so much ahead of time. Furthermore, the school district has taken a stance typical not only of modern wokeism, but also of too many school administrators who seem to think they have a brief to promote atheism. That should be enough for one of the players to sue the district for an unconstitutional promotion of atheism. Or does the Establishment Clause work only one way? Does avoiding establishment of religion really require the government to establish anti-religion, meaning atheism or secular humanism. That, unfortunately, is where Neil Gorsuch's opinion leaves us. It also goes to the flaw in Justice Alito's opinion in the Dobbs case, namely that he didn't consult the source. This court definitively has an atheistic caucus within it, consisting now of Justices Breyer, Kagan, and Sotomayor. Against them, we have only Justices Thomas and Alito, and maybe Barrett, willing to defend the faith or anything consistent with it. In the middle, we have Chief Justice Roberts and Justices Gorsuch and Kavanaugh. They seem to plump for neutrality. All of which goes to show how far people of faith must go and how hard they must fight for a return to the jurisprudence of the framers. Sotomayor clearly and willfully misrepresents the framers. This isn't about them at all. It is about James G. Blaine of 1875. Only this time, someone advanced an argument going further than any Blaine amendment ever did. But the Second Great Awakening has two toeholds. First, Coach Kennedy got his job back on terms that allow some prayer activity while on duty. Second, government programs that benefit some must benefit all, religious or otherwise. With these understandings, people of faith have recovered at least some of the ground they lost to the Blaine wave. Furthermore, we can use this ground to our advantage in nurturing the next generation. But it might take another generation to sweep aside this wrong-headed understanding of the Establishment Clause. In the meantime, we must pray that God guards the lives of the conservatives on the court, especially Justice Thomas. As the senior member of court, he invites doubts, real or specious, about his health. His earlier statement against substantive due process now makes him more of a lightning rod. And we have seen President Biden appoint an even worse replacement for Breyer to that atheistic caucus on the court. And she does not even know what a woman is. Can Thomas and his conservative colleagues survive 2.5 more years of President Biden and maybe President Harris? Stay tuned. Links to the description to the article, to the opinion, and the conservative news and views. I have another link to the awesome CNAV Store and to BitNext, as I also mentioned. And if you like what you've heard, you can like this video and subscribe to this channel. There's always a button underneath the video. And check out the in-video links to 2 more videos. My discussion of the Supreme Court's repudiation of James G. Blaine in the Carson case, and of the substantive due process question Clarence Thomas raised in the Dobbs case. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.